Well, what's funny is that they say under the NFA, these are firearms.
I know. Well, that's
It's hard
what
for them
they're
to get out
arguing
of it.
against themselves, right? Yes,
Right.
they are firearms under the NFA, but it's not the worst argument.
No. We are the Armed Attorneys. Today we're talking about oral arguments that was just heard in an important case that might invalidate the National Firearms Act. So we're going to be talking about that case, how the oral arguments went. We are going to pull some clips from it to just kind of show you all how these things take place, and then what we think ultimately is going to happen. And this is all about the Made in Texas suppressor law that passed a few years back. It's winding its way through the courts. Maybe we're getting some progress on it. But before we begin, show your support for the Second Amendment by hitting that like button. And this video, it centers around the Made in Texas suppressor law. So for the uninitiated, what's going on?
Well, I was actually just staring at the camera lens thinking to myself, was Made in Texas Suppressors passed in 19 or 21?
2021.
It was 21. Thank you, Richard. So what we have...
If I'm wrong, it'll be up on screen.
All right. So what we have is a very interesting law in the vein of ones that were passed previously by, I believe, Kansas and Montana, which essentially said, look, you cannot regulate that which is not interstate commerce. Interesting if true, because virtually everything is interstate commerce. And so essentially what the Texas law did, in a valiant attempt to distinguish itself from the laws that other circuits held were actually not going to exempt them from interstate commerce, Texas tried to kind of dance around that and say, here's what's up, guys. As long as the suppressor is made completely within the state of Texas with materials that were produced and housed completely within the state of Texas, you can make that suppressor without it invoking the NFA and interstate commerce. So no tax stamp, no registration. But because we know that you're worried about, let's say, sitting in federal prison for quite some time for doing so, the state of Texas is going to seek an injunction ahead of time on your behalf, so long as you let the Attorney General know that you intend to engage in this practice of making a suppressor. Maybe you have a business, maybe you want to sell them. We are going to file a lawsuit against the federal government on your behalf, get that injunction before you sit in federal prison for doing so, and we're going to make this interstate commerce argument for you. And this actually was passed before Bruin, because I think now we've even added to our potential arguments for why you should be able to engage in this activity. But that's our Made in Texas suppressor law. It is 4 years old, which should tell you something about the way these things work now.
Yeah.
And we are getting to the point of, okay, we are actually sitting in front of the intermediate, not the Supreme Court, the intermediate Court of Appeals on these issues.
But it's not as spicy of an issue as you would hope. And just to...
Isn't it?
But well, it's standing. But it's important, and the court is showing its hand here, and so I think that's why it's so important, and obviously why you want to stick around. But we look at our Commerce Clause cases, and I want to say there was a barbecue joint out in the middle of nowhere in the Carolinas who had napkins from a napkin manufacturer. And they're like, well, you got napkins made across state lines. Your entire barbecue joint out in the wherever.
We're talking about your wheat. Your wheat.
Yeah.
Right? I mean, we're talking about your wheat grown only in your state.
Wickard v. Filburn. Those bastards.
Wickard affects interstate commerce. Everything affects interstate commerce.
Yeah. In that case, if you aren't familiar with that case, this guy was a crop, growing wheat. He grew more than he was allowed to, and they said for his own family and consumption, and they said that's going to affect commerce, so you can't grow any excess wheat. That's how screwed up the Commerce Clause is. All right. Soapbox over. Going back to this case. So it's a standing issue, and this case went to the district court in Texas. They said, hey, you do not have standing, state of Texas. You cannot just legislate standing on behalf of your citizens.
Can't you?
And they dismissed it. And so then we go up to the Fifth Circuit Court of Appeals. That's what we're listening to here today. So let's go to clip A.
And it's not disputed if they were to go home and make these devices without seeking the federal government's permission, without registering the devices, without serializing the devices, and without paying a $200 tax, if granted permission to make the devices, it's undisputed that they would face 10 years in prison.
And so, I don't know that the government disputes that if you make unregistered suppressors in your house that you're going to be subject to getting arrested.
No, but they do dispute that, like, you don't have standing until you are arrested, which is crazy to me.
So, and they're
Crazy to me.
and I think they concede, they're saying it's not the facts of this case. They do concede, like, hey, if you fill out an application and we hold on to it for too long and don't approve you, we're talking about a Form 1,
Form
an
1.
application to build an NFA item. Here we're talking about suppressors. If they hold on to it for too long, maybe you get standing, or if you're denied, then they say you absolutely get standing under those circumstances. But it's very, very, very wishy-washy, this whole thing. But everybody agrees you have an unregistered suppressor. They're going to go after you to serve some serious time.
You got standing for sure.
Then we have another interesting argument. We hear it come actually from the court saying, are suppressors even arms? So let's check out clip B.
The U.S. Supreme Court has told us in Heller, in Bruin, they describe arms as articles, modern instruments that facilitate self-defense. It's a very broad definition for what an arm
Well, we're
would
going
be.
to find out what they say about Bruin, I guess, shortly in Rahimi, but still, you've got where's the case law that says a silencer is protected under the Second Amendment?
There is no case that says a suppressor silencer is an arm. That's a question that I think ultimately may get to this court. I don't think it's primed for you to rule on that today.
And the court's not, as you heard, they're not even looking at whether the Second Amendment is implicated at this hearing.
Which is interesting because I actually think, as much as I disagree, I think it's a decent argument. And fundamentally, as a principle, I think
Right.
suppressors should be arms. It's not the government's worst argument, though.
Well, what's funny is that they say under the NFA, these are firearms.
I know. Well, that's
It's hard
what
for them
they're
to get out
arguing
of it.
against themselves, right? Yes,
Right.
they are firearms under the NFA, but it's not the worst argument.
No. And then, so we're talking about, obviously, there's some individual plaintiffs. There's the state of Texas. They make these arguments about why Texas should have standing. This is all coming from the individual plaintiffs in the state of Texas. They make all of their arguments. And then we get the government's oral argument, their official submission to the court, which I am not kidding you, lasts 10 seconds long.
The district court correctly held that no plaintiff has established standing to challenge the NFA's restrictions on making silencers and dismissed plaintiff's complaint without prejudice. This court should affirm.
And
I
then-
mean, again, I will say, and I feel like I'm giving the government a lot of credit on this one. That's the strongest argument you could possibly make on appeal.
standing.
No, that's if your argument is the district court got it right.
Yeah.
I
see what you're
That's
saying.
how you win appeals.
Well, and I
is
mean,
that you be the appellee.
right. And we see that, file on the criminal side of things.
Yes.
When the state of Texas appeals a ruling that they don't like, I mean, we file an appeal saying, we'll brief this if you want, but we don't think we need to brief it. So I guess
Right.
I get
No,
what you're...
that's the best argument you have is, don't you worry about this. Don't you worry about this, Fifth Circuit. They got it right before. Don't you worry about this. That's always, if you're not saying that's this particular best argument, but if you are the appellee of anything, that is your best argument.
Yeah. And this is where we get, the government's up in the hot seat now, and this is where we get some substantial pushback from the court. Checking out clip D.
What would it take for plaintiffs to have standing to challenge? I mean, I don't understand how the government can promulgate a regulation that says, show us photos of all the stuff you're going to use, and if in our discretion we deny you a license, the FBI is going to be at your door tomorrow. In other words, how can the government require self-incrimination, potential self-incrimination as a basis for regulation?
And so, we don't have it all in all the clips because, that's a long oral argument. We're going to keep this stuff brief for y'all. But what we do see the court, they do go over how, these folks who are applying their ATF Form 1s, application to build an NFA item, specifically suppressors, the government was requesting that they provide photographs and all these things. And what we saw as practitioners for a while, like, for example, solvent traps.
Mm-hmm.
People were buying solvent traps, filing their Form 1s,
Do the Form 1.
getting approval, building it, good to go. Well, then the government started saying, send us photographs, and people were sending them photographs of these unfinished solvent traps, and the government was saying, these are already completed suppressors. So we are denying your application, and you're on notice that you're in possession of an unregistered NFA item. So the court does a pretty good job of pointing out hey, look, you're telling people they have to incriminate themselves in order to gain standing, which I think is somebody has to be able to sue for this violation of the Second Amendment. And I think that's what everybody's just trying to figure out.
And then we have a Fifth Circuit justice bringing us what I think is probably my favorite part of this entire argument. And again, we are still talking about speculative standing.
Yeah,
right?
the state getting standing on behalf of its citizens.
Yes, but it's pretty spicy.
A state cannot bring a lawsuit against the federal government if the state is really asserting the interests of its citizens. And here, I think Texas is just saying they would like to assert their interests.
What was the interest asserted in Massachusetts versus EPA?
So there were two interests, Your Honor. One, the substantive interest was that, Massachusetts' view, part of the state.
Water was going to rise.
Right. Part of the state was going to be submerged. That's a
Which
pretty...
of course, 30 years after the fact is demonstrably untrue, but that was good enough for a hypothesis, right?
I think the interest there, or the claimed injury there, and whether or not that injury was borne out or not, I don't know. But the claimed injury was that part of the state was going to be submerged. I think that's a pretty core territorial...
Well, tell the Obamas that.
News to the Obamas, why are you buying beachfront property if the sea levels are rising? And I'll say generally, I listen to a lot of oral arguments. Usually they don't get that political.
We don't get that political.
So I think the next fair question is, what is the likely outcome of this appeal? Because again, and we've had these kind of discussions before, when the district court does what we like and then it gets appealed and they grant it, it's like, that's usually not a good sign. That is an indication that maybe the district court did something that the Superior Court didn't like. What do you see about them granting appeal here and hearing the argument on standing?
I think I think we've got a good shot. I think when we look back at, I want to say it was the 10th Circuit, which reviewed a similar such law. And essentially the 10th Circuit looked at it and said, well, and this is not the standing issue, but this is just generally, the 10th Circuit gave a nod to, they already had standing and they said, we don't like your interstate commerce issue. However, you really should have argued this on Second Amendment grounds, because they probably would have moved somewhere on Second Amendment grounds. I think the Fifth Circuit is likely to say you do have standing. And then I think we're likely to get a very interesting, not necessarily interstate commerce decision, but a very interesting Second Amendment based decision out of this. That's what I think.
Yeah, I think I don't disagree with you very much. Pretty much aligned there. Taking this case, hearing this case, I think we're going to see them tell the trial court, hey, they have standing, go back and evaluate this case under... And I think the Second Amendment's getting roped into this.
I think the Second Amendment's getting roped in.
And so if we're going to look at whether suppressors are implicated by the Second Amendment, I have a good feeling about that.
It is going to be something, if it's going to happen, I want it to happen in the Fifth Circuit.
That's exactly right. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, question and comment for us below. Until next time, we're the Armed Attorneys.